Hello and welcome to another edition of Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the Nachman Fawani Zimochek Law Group. And we have offices in northern New Jersey. We also have an office in Midtown Manhattan. We have affiliated offices in Mumbai, India, in Bandra. And we also have an affiliated office we actually have two affiliated offices in Canada, one in Toronto and one in Montreal, where we're able to meet with our clients. So today I wanted to discuss with you some of the issues surrounding what's called the petition to lift the conditions, or the I-751 process. And by way of background, I just want to explain to you a little bit about how the I-751 process works. So the I-751 was actually implemented under the Marriage Fraud Amendment Act of 1989. And the Marriage Fraud Amendment Act says that what happens is when you go and you have the marriage case, when you go for a marriage case, and that's an immediate relative. So when a foreign national marries a U.S. citizen, what happens is that the case is granted on a conditional basis. So the individual receives what's called CR6, or conditional residence, for a period of 2 years. And then what happens is, following that 2-year period, after the individual has their green card, then what they have to do is 90 days prior to the second anniversary, they have to go back to the Immigration Service and they have to lift those conditions. And once again, it has to do with demonstrating that it's still a bona fide marital relationship. So that's what the petition to lift the conditions is all about. Now, there are several permutations on this process. And oftentimes we'll receive calls from individuals who will explain to us, let's say, somewhere along the way, it might be within that 2-year period, that their marriage is breaking down, things are not working out. Well, in order to file this petition as a joint petition 90 days prior to the second anniversary, there has to be still a bona fide marriage. So for both people to sign the petition to lift the conditions, the I-751, they have to be still involved in a bona fide marital relationship. Now, it could be that maybe that bona fide marital relationship is on the rocks. It could be that things are kind of bumpy, as opposed to actually being a good marriage, if you will. But that doesn't preclude you from filing the joint petition. If the two parties agree to file the joint petition, then that's okay. So what kind of documentation is necessary at this point in time? Well, it's sort of the same type of documentation that we submitted with regard to the bona fides of the marital relationship when we did the simultaneous filing of the I-130 and the I-485. The difference is that what we want to do is try to get information or evidence, and it can be primary evidence, which of course is best, and primary evidence would be, for example, a copy of a lease that's signed by both parties, could be a copy of the insurance policy that both the spouses are listed on the insurance policy. It could be any number of documents to demonstrate the joint financial interest of the parties. So for example, maybe even the filing of an income tax return where both parties are listed, of course, on the income tax return, a joint filing of the income tax return. These are documents that demonstrate the bona fides of the marital relationship. So what we would be looking for before we file the I-751 from an individual who's interested in filing that would be that they show these documents over the span of that 2-year conditional residence period. So these would be the types of documents that we would like to file with. Now, the procedure works something like this. What we do is we have both parties sign the I-751 if we're filing a joint petition to lift the conditions. Normally we file that 90 days prior to the second anniversary of when the individual got their green card, and we would include all the supporting documentation. That would be sent into the USCIS, and what will happen then is probably about a week to 2 weeks later, a receipt document will be issued, and that receipt will give the foreign national spouse the ability to continue their work authorization, and it essentially extends the green card for 1 full year. So what they should do, of course, is to continue to travel with their conditional green card and with the receipt notice, and that's what they would be able to use for that 1 year period of time during which the USCIS has the ability to adjudicate that I-751. Now, a particular permutation which we see in our office might be a situation where, for example, the individual may be divorced. If the individual is divorced prior to the second anniversary, it doesn't preclude the filing of the I-751. In fact, if the divorce is effectuated prior to the second anniversary, the individual can go ahead and file on their own. Now, there are two sort of permutations, if you will, to filing. These are called waivers of the joint filing requirement. So the first waiver is where the individuals entered into the marital relationship with the expectation that it was going to work out, that it was bona fide, but that it was subsequently dissolved by divorce. So that gives the individual the ability to go ahead on their own and to file a waiver application. The waiver, again, essentially is that you're asking the government to waive the joint filing of the I-751. The other permutation, which we often see, is where the individual, unfortunately, has become the victim of extreme abuse or is a battered spouse. And that also gives you the ability to file the I-751 without the other spouse. So it doesn't have to be a joint filing, it can be a single filing. So those are the two permutations which we've seen. Now what's really important to know is that whereas with the filing of the I-751, where you have a time that you have to file, the 90 days prior to the second anniversary, or up to at least the time that the 2 years, if you have a divorce, there's no time set. So as long as you have the divorce, you can go ahead and file for the waiver. So you don't have to worry about that 2-year period of time. So that's the basis for the I-751. And then the other thing that you should know, of course, is that after the conditions are lifted, if you're still married to the individual from whom you got the green card, you can go ahead and apply for citizenship 1 year after that 2-year anniversary. So you can go ahead and apply for citizenship if you remain married and you were able to file the joint petition to lift the conditions. If you were unable to file the joint petition to lift the conditions, then what you have to do is you have to wait, and you're not married anymore to the individual who got you the green card, then you have to wait 5 years. So 90 days prior to the 5th anniversary, then you can apply for U.S. citizenship. So I hope that this information is helpful to you with regard to the I-751, the petition to lift the conditions on conditional resident status, which individuals who marry foreign nationals get. And again, this comes out of the Marriage Fraud Amendment Act. If you or any member of your family or any of your friends have any questions with regard to the I-751, the petition to lift the conditions, please give us a call. We'll be more than happy to assist you. Thanks very much for tuning in today, and we look forward to seeing you again. Thanks very much. Bye now.